This is Dr. Mark Leiser. I've decided to do a series of 5 lectures on why I think the Digital Omnibus is so important to protecting and extending fundamental rights. This is the third of those 5 lectures. The question today is simple to ask but difficult to answer. When does ordinary personal data become sensitive data? That matters because sensitive data receive stronger protection under the GDPR. I will use one fictional mortgage application to explain the boundary. We will follow ordinary inputs, a sensitive inference, and a lending decisions. Then we will see why the omnibus needs to protect people without treating every possible hint in an AI system as deliberate sensitive profiling. Imagine Mara applies for a mortgage. The lender receives familiar information, her income, employment, debts, and payment history. On their own, these are ordinary personal data. Transaction descriptions may reveal Mara's health, religion, politics, or trade union membership when the model combines them. The system might also encounter an isolated sensitive reference in old training material without seeking it. The model then produces a risk score. If a sensitive inference shapes that score, the legal concern becomes much more serious. If the bank rejects Mara automatically, another rule, Article 22, may also apply. If a person genuinely reviews the evidence and can reject the model's recommendation, the position may be different. So separate 3 things: what enters, what meaning emerges, and who makes the final decision. Lecture 2 dealt with the GDPR's outer boundary. Is this information personal data for this actor in this situation? Article 9 draws a boundary inside the GDPR. It covers particular kinds of information, including health, political opinion, religious belief, trade union membership, and sexual orientation. The law gives these categories stronger protection because their misuse can create particularly serious harm. That inner boundary must do 2 jobs. It must stop organizations avoiding protection by deriving sensitive facts from ordinary data. But it must also remain a boundary. If every weak or theoretical link to a protected trait counts as sensitive processing, Article 9 loses its ability to distinguish the exceptional case from ordinary data use. Mara's file therefore asks when the processing really crosses that inner line. Ordinary data can reveal sensitive meaning. A database label does not settle that question. A lender could infer Mara's health from payments, locations, or repeated behavior without asking her directly. One payment to a pharmacy might reveal very little. A sustained pattern involving a specialist clinic, a particular treatment, and related purchases may reveal much more. If the system builds a health inference and links it to Mara, the fact that each input looks ordinary does not remove the sensitive meaning. But almost any ordinary fact might have a weak statistical link with health, religion, or politics. A remote possibility is not the same as an actual revelation or use. Ask what meaning the processing makes available about the person and whether that meaning affects action. That protects people against hidden inference without turning every ordinary data point into sensitive data. The Court of Justice has repeatedly looked at what information can reveal in context. In OT, information about a spouse could indirectly disclose sexual orientation. In Meta, online behavior and website visits could reveal protected characteristics when combined. Linden Apotheke applied the same logic to health. Information supplied when ordering certain pharmacy products could reveal health status, even without a formal diagnosis. Schrems versus Meta added an important restraint. One public statement does not give a platform a general license to use other sexuality-related information for advertising. The high-level lesson is that substance matters more than the name of a field. An organization cannot escape Article 9 merely because it collected transactions or clicks, rather than asking a sensitive question directly. For Mara, the bank must examine when its model actually reveals and uses. A feature called merchant pattern may still carry a health meaning. Recognizing inference is essential, but it creates a second problem. If Article 9 applies whenever a sensitive conclusion could possibly be drawn, then almost every large dataset becomes sensitive in theory. My report proposes a clearer limit. Stronger protection should apply when processing meaningfully reveals or uses a protected characteristic. A model built to predict health for credit assessment is an obvious case. An unexpected health proxy also needs action if it affects outcomes. An isolated medical phrase left in a large training set after sensible screening is different if it neither profiles person nor shapes a decision. The law should require a controlled response without treating that trace as a deliberate exploitation. Purpose helps us understand the operation, but stated intention is not a loophole. What the system reveals and uses remains decisive. To find that boundary, ask 5 plain questions. What data was entered? What sensitive meaning emerged? Was that meaning sought? Did it shape the output? Did it affect a real decision? Together, the answers show what the processing actually does. No single answer does all the work. A controller cannot avoid Article 9 simply by saying that a sense of inference was unintended. If the system reveals and uses that inference, the risk is real. Deliberately predicting Mara's health to change her score clearly crosses the line. An unintended health proxy that affects outcomes needs investigation and correction. An isolated reference that shapes neither output nor action sits differently. This is a boundary based on what the processing does, not on a convenient label or a purely theoretical possibility. Large AI training, testing, and validation datasets may contain sensitive material that the developer did not seek. Removing every reference can be difficult because the developer must first recognize its meaning. That practical problem must not become a broad permission. A developer cannot design a system to collect diagnoses, political opinions, or sexuality and then call the result incidental. Nor can a lender use a sensitive feature in a decision and describe it as a harmless residue. Genuine residue needs a workable root. Suppose screen training text still contains one medical reference. The model does not infer health. The fragment does not shape Mara's score, and controls keep it out of outputs. Treating that like targeted health profiling would blur Article 9's boundary. The goal is strong protection against exploitation, combined with clear duties for unavoidable traces. The proposed Article 9, subsection 2, subsection K tries to solve that narrow problem for AI development and operation. In plain English, it would create a root for incidental or residual sensitive data, but only with added safeguards. Those limits are important because the provision should not permit deliberate sensitive profiling, systematic collection through user prompts, or the use of protected traits in downstream decisions. Those activities need the full protection Article 9 already demands. For genuine residue, use an ordered path, avoid collection, screen, and minimize, remove where reasonably practicable, then isolate and protect what remains. Keep it out of outputs, record the response, and reassess when the model changes or is reused. This is not an exemption from responsibility. It's a narrow way to manage a problem that responsible developers may face even after taking precautions. In Mara's case, it cannot legalize a health-based mortgage score. A safeguard cannot be a one-off exercise performed when a dataset arrives. AI systems change as data are curated, models are trained, tests reveal problems, and organizations place the system in new settings. At source, define the purpose, choose suitable data, and minimize likely sensitive content. During development, screen the material, test for sensitive inferences, and reduce the chance that the model reproduces protected information. Deployment needs a fresh look because a new use may create a new risk. Control inputs and outputs, monitor what the model reveals, keep useful records, and act when testing finds a proxy. This lifecycle approach is important for Mara. A clean dataset report does not prove that the live mortgage system ignores health. The bank needs evidence about the deployed model, the score it produces, and what happens when monitoring reveals a problem. Two parts of the GDPR are often mixed together in the AI debate. Article 6 asks whether there is a lawful basis for processing ordinary personal data. Article 9 asks a separate question when the processing involves specially protected data. An organization may therefore need two answers. A lawful basis under Article 6 does not automatically open Article 9. Equally, a narrow Article 9 route for residual sensitive material does not remove the ordinary requirements for necessity, balancing, transparency, and protection. The Commission's proposed Article 88C to clarify when legitimate interest might support some AI development and operation. The report argues that any such route should be narrow and binding, not a blanket permission. It would address ordinary personal data. The proposed Article 9 subsection 2 subsection K would do a different job for incidental or residual sensitive rate data. For MARA, the lender cannot make a health-based scoring model lawful merely by naming a legitimate interest. It must answer the ordinary lawfulness question and the stronger sensitive data question separately. The last part of Mara's story concerns the decision. Article 22 protects people against certain decisions based solely on automated processing when those decisions have legal or similarly significant effects. A mortgage refusal makes the issue easy to understand. The court's Shufa judgment confirms that Article 22 is framed as a prohibition in principle, subject to stated exceptions. The omnibus should preserve that basic protection. Simplification should not turn automated rejection into the default. The harder question is what counts as real human involvement. A person who sees only a score, has seconds to respond, and is expected always to follow the system and not making an independent decision. That is a rubber stamp. Meaningful review needs 5 things. The reviewer needs enough information to understand the recommendation. They need time and skill to assess it. They need authority to disagree, and the organization must record and support that responsibility. The AI Act can help through risk management, data governance, logging, and human oversight duties, but those system-wide controls do not replace the individual protection in Article 22. The two regimes look at different parts of the problem and should work together. If a capable employee genuinely reviews Mara's evidence and can overturn the score, the system may remain decision support. If the employee merely clicks approve, the decision remains automated in substance. Let us return to Mara's mortgage application. First, ordinary data can become sensitive when the processing genuinely reveals or uses of protected characteristics. The name of the input field does not decide the matter, and a controller cannot avoid protection by hiding the inference inside a model. Second, not every possible sensitive trace is the same. Deliberate profiling and an unintended inference that shapes the decision require strong action. Incidental residue that survives sensible screening but does not drive an output needs a narrow compliance route built around avoidance, removal, isolation, testing, and review. Third, adding a person at the end does not automatically solve automated decision-making. Meaningful human review requires information, time, skill, authority, and accountability. A person must be able to make the decision, not merely confirm it. These distinctions protect Mara while keeping Article 9 usable as a boundary. They also show the central value of the Digital Omnibus. It can turn difficult legal concepts into clear operating rules without weakening the rights those rules exist to protect. The next lecture moves from one AI-assisted decision to a wider problem. The same activity can face several overlapping rules on cookies, research reuse, and European data spaces. That is where legal uncertainty multiplies. Continue to Lecture 4, the friction multiplier. Watch Lecture 4 next, where I explain how cookies, research rules, and Europe's data spaces multiply legal friction. Then continue with the other videos in this lecture series.